signed up. The next, just in case I forget to mention it at the end, the next breakfast briefing after today will be on the 3rd of August, the first Wednesday in August. And it'll be on a topic around contracting with the public sector. And it'll be hosted by our trainee solicitor, Amy, as she used to work with North Ayrshire Council and worked in the procurement department. So she's got a bit of inside knowledge there. So without further ado, I think I'll just share my screen and we'll get cracking on today's session. So can somebody give me a thumbs up if you can see this, or let me know? Good, thank you. So we'll just crack ahead with the breakfast briefing on investigations. So the things we'll cover in this brief session today will be, firstly, what evidence you should be considering. Secondly, how you should document your investigation, what information you need to keep hold of and have available. And also having a look at the potential outcomes from an investigation, because it can be the case that you start off with something that's quite, seems to be quite obviously a disciplinary matter, but by the end of the investigation, you might not be so sure. Or you might start off with something you're investigating that you might think is capability, but it ends up it's conduct, or vice versa. So it's important to document the outcomes and where that might lead you. So I'll be talking about investigations in the context of disciplinary process today, but you can use the information with regards to any investigation that you conduct, because a similar process, if you follow a similar process, you'll end up with the correct result, or should end up with the correct result. So most companies have a disciplinary procedure within their organisations, and that may contain some information about how to conduct an investigation. And that has to be read in conjunction with the ACAS Code on Disciplinary and Grievance Procedures. There's a link to that code in these slides. The words highlighted in blue will give you a link to the code. And it's important to read that as well as your own disciplinary procedure, because you are required as a kind of basic minimum to follow that ACAS Code. If there's any conflict between your own company disciplinary process and the ACAS Code, you need to consider which one you should follow and if there's a good reason for what you're doing, because while the ACAS Code is not absolutely mandatory, if you fail to follow it without a good reason and a claim is then made against your organisation and is successful, there's the potential for the tribunal to award an uplift of up to 25% on anything they award to the claimant, for example, for unfair dismissal. So it is really important to have a look at that ACAS Code and Disciplinary and Grievance Procedures, as well as your own company disciplinary procedure, and see what that says about investigation. And one of the key things you tend to find in both the ACAS Code and company procedures is that there shouldn't be any disciplinary action taken until a proper investigation has been conducted. So as I said, familiarise yourself with both the company policy and the ACAS Code. And it's a good idea as well, when you're conducting an investigation, to prepare in advance of the meetings. So prepare your questions, prepare in terms of what you're going to have to be looking at. Try to keep an open mind and don't assume anything. It can be difficult. We're all humans, particularly if the most troublesome employee that you deal with on a regular basis appears before you accused of something or other. But it's important that you do keep an open mind, because it's a very easy accusation for somebody to make later. Oh, the whole process was biased. The investigation officer had made up his or her mind before I opened my mouth. They didn't listen to anything I said. They determined it in advance. So it's really important not to put yourself in that position, to keep an open mind and assume nothing. So as I mentioned, it's usually a key provision that every issue of conduct or performance should be investigated properly before the disciplinary process is instigated in terms of the ACAS Code of Practice. Now, you'll probably all be familiar with the concept of gross misconduct. That's the sort of very serious acts of misconduct where, for example, there's a physical fight, or someone's turned up for work drunk or under the influence of drugs, or there's an allegation of theft or fraud, or something of that nature. So that's a really serious examples of misconduct, which can lead to an employee being dismissed, and dismissed without notice at that. And historically, it's been quite common when an allegation of gross misconduct has been made to suspend the employee pending an investigation, But there's case law now that suggests that shouldn't be your automatic response, that you should consider whether or not to suspend the employee. And it's usually only now recommended that you utilise that route if either you think that the investigation is at risk of being compromised somehow. So, for example, evidence tampered with, removed, destroyed, or witnesses are prone to being intimidated by the person accused. So these are the two scenarios where you might think about suspending. Suspension in this context is not a disciplinary penalty. It's simply to preserve the status quo and allow the investigation to be carried out free from interference. The suspension should be as short as possible. So it should be as short as it can be, because obviously somebody is waiting for the outcome. And as per most companies' policy, a last resort. The suspension should be with full pay. It shouldn't be without pay at this stage. It's simply to preserve the status quo. So how did one of the things in your initial planning is to find out or to ask the question, how did this complaint come to light and when? Because if the answer you get to that question is, well, it happened about 6 months ago, I'd be wanting to know, well, why have we done nothing about it for 6 months? Or, have we potentially missed the boat with this particular issue? When there may be a valid explanation as to why it's taken 6 months or it's 6 months since the incident happened, but you need to understand what that was and take a decision about, is it appropriate to continue with an investigation in view of the time lapse? It's also useful to ask, who's asked for this investigation and why are they asking for it, to understand what the basis of it is. And again, you should check your company procedure and also the ACAS Code in case there's any direction about how the investigation should take place, because there are certain statutory requirements about, but sometimes the company procedure can go further. For example, the statutory right to be a company doesn't apply at the investigation stage, but your company procedure may provide for that to be permitted. So you need to check what your company rules say. Think about who should conduct the investigation. Are they impartial? Have they got sufficient experience? If they don't have they got someone to guide them through the process, somebody that they can refer to for advice on the process? And also be clear, who's conducting this? Is it the line manager or is it HR? Because there's case law that essentially says that really it's the line manager who should conduct an investigation. HR is there to guide, to advise on process, to advise on precedent, and also past how you've dealt with things in the past to ensure consistency, but it's not there to actually conduct the process. It's a case called Ramphal against Department of Transport, if anyone wants to have a look at it. In terms of the allegations, you need to be very clear, what are the allegations? This isn't the opportunity to investigate everything the employee's ever done in the whole history of their employment, even if they are one of those troublesome employees. You need to ask yourself, in relation to that allegation, what questions do I need to answer in order to make my fact finding in the investigation? Who do I need to speak to? What witnesses should I interview? And what other evidence do I need to consider and gather in as part of my investigation? For example, it might be timesheets, it might be training records, it might be clock cards, it might be CCTV footage if there's been some sort of incident that you need to see, if there's any sort of visible evidence of. We're often asked if witnesses need to sign the statements they give, and the answer, legally speaking, is no, they do not. But it's good practice to give the witnesses an opportunity to read over their statements, to tell you if they're satisfied with the content or tell you if they want to change anything, and then to sign and date them, because that also gives you some comfort later on in case you start becoming less enthusiastic about being a witness when things move on to being more serious, if it moves on to disciplinary process, for example. But you've then got good evidence of what they told you at the time, which you can then rely on if they start backing off or cooling down in their enthusiasm for being a witness. We're also quite often asked, should you have a standard form for carrying out an investigation and asking your questions? I would suggest that's appropriate if you need to ask a number of people the same questions. So, for example, if a group of people are alleged to have been present when some incident happened. In that case, standard questions on a standard format would be a good idea, because it makes sure you ask them all the same questions in the same order, in the same way, and you can then compare the answers you get from all of the witnesses. And you also make sure you don't miss anything out with any of them. But other than that, I think you just need to tailor the questions to the witness and what they're meant to have seen or heard or be knowledgeable about, and tailor your questions accordingly. Have a think about the order in which you take people. I would suggest it's normally first the person who's making the accusation, and then secondly, the person who's accused, and then thereafter anyone who's maybe got information to contribute about what they saw or heard happening. And always remember to speak with the person accused as part of your investigation. It's fundamental to a fair investigation that they have the opportunity at that stage to tell you their account of events, and you take that into account in deciding what the next steps, if any, will be, that you actually have their account of what happened. Speak to witnesses one at a time, not in groups, because they can come under peer pressure not to speak or to say a certain version of events. So one at a time is best. Prepare your questions in advance. It gives you a bit of comfort that you're not missing anything, and allows you to conduct the interview in a more confident manner. That's not to say you won't have to ask some additional questions, as people can jump off at tangents and give you information you weren't expecting, and you may have to, interrogate that a bit further, but at least gives you a basis for your interview. When I say establish the relationship, what I'm meaning there is, did the witness see what happened? Did they hear something? Or, is the relationship they have to the events that they're an expert in in relation to a process? So for example, if a part's been damaged and the employee says, well, I did X, Y, and Z, or I followed your process. If you've got somebody really experienced in the process or knowledgeable about the procedure, you might say to them, well, if we did X, Y, and Z, could this have been the outcome or not? And, what's the reason for your answer? And you've got a kind of expert opinion there. So just have a think about what part the witness plays in this, what the relationship is to the event you're investigating. What do you do if the witnesses request, or any of them request, anonymity? They don't want their name put forward to say, I'll give you a statement, but I don't want the person accused to know it's me. I would say that can be okay, but you need to treat their statements with a bit more caution. You need to be satisfied that there is a genuine reason for asking for anonymity, because I wouldn't be keen to grant it, just for the hell of it. I'd want to know why they were asking for anonymity. And the usual kind of thing is they're afraid of reprisals from the person accused or their peer group. If that's the case, fine, go ahead, give them anonymity. Be clear that you might not be able to guarantee that if the matter ever went external to the company, but internally you can. And just treat their statement with a bit more caution. Explore whether there's any history between the two of them, any bad blood, and somebody could be trying to get revenge. But if you're satisfied it's genuine, then it's fine. When it comes to passing on that person's statement, if matters progress to disciplinary, you will need to make sure you pass on the crucial bit of information, but delete anything or redact anything that identifies that person. So obviously their name, but it may be if they're the only person that works in a particular area or process, you might have to take out that information. And you can either provide the statement with the information redacted, or simply provide a list of the key points that witness has told you about in giving their information. When it comes to questions, make sure they're, as far as you can, that it's open questions. Don't put words in people's mouths. So ask questions, particularly questions that start with what, are really good, because you're not telling anybody your own version of what happened. You're saying what happened and allowing them to tell you what happened. And also other questions about, who was there, when did it happen, where did it happen? Again, all questions that are not putting words in somebody's mouth. It's not your perceived version of events, it's them giving you their version of events. You might, of course, have to ask some questions about why you think that happened, or why do you think that was the case, which is asking for opinion. But as long as you're clear you are asking for an opinion and why you're asking for an opinion, that is fine. Make sure your questions are relevant to the allegation. Again, it's not an opportunity to interrogate the entire work history and potential wrongdoing over the whole of that period of this employee. It's questions that are relevant to the incident you've been asked to look into, or the allegation you've been asked to investigate. So I thought I'd do a wee walkthrough case study, just as a matter of interest, just to give you an idea of the kind of strands of questions that you might have to think about during an investigation. And the point of this being that it's not always just about what the employee did. There might be a wider issue to consider, not just what the employee did. So the scenario is that the employee doesn't work directly for you. You managed him a number of years ago. The line managers claimed that the employee dropped a gearbox from his hands onto the concrete floor, which has led to the part having to be scrapped at a cost of £60,000 to the business, which is not unsubstantial. The line manager says that this employee knew the part required either 2 people to lift it or a crane to be used if there aren't 2 people available to lift it. But in his initial review, the line manager says, well, the employee denied being aware of the 2-person or crane lift rule, and also said his training for slinging had expired, so he'd been told he couldn't use the crane. The employee's position is that the part was to be scrapped anyway, and it had slipped from his hands because oil had leaked during a pressure test, which would mean it would be scrapped, and he was taking it to quality, who would condemn it. The line manager also said, well, X is also always breaching health and safety rules, and he'd asked HR to intervene. And he didn't know if any of the 16 people in the team witnessed the incident, but believed some would have overheard their exchange after the part was dropped, thereby implying there was raised voices, probably, from what he says. So in terms of the sort of questions we thought about, who do you need to speak to, what order, and that would generally be the manager first who's making the allegation, then X, and then any of the people on the team who might have heard. You might also want to speak to somebody about training records, and also about, well, who's got the authority to condemn the part. Is it X, or is it quality, or is it the line manager who can say this part is now beyond being saved? So there's a number of different things you might want to ask for and speak to people you might want to speak to. And documents might include the training records, it might include sort of general risk assessments for the job, it might include general health and safety briefings for the whole team. We'll go through questions for the line manager and X, and we'll have a think about questions for any other witnesses, and so forth. So the questions for X, the first questions focus on his part in the incident. So what happened? Where were you taking the part? Why were you doing that? How far away is it? Why didn't you ask for help? You know it's heavy. Why didn't you use the crane? Have you done this before? What safety measures did you take to reduce the chance you might drop it? Because he's telling you it's covered in oil. So I think that's a legitimate question. Did you know how valuable it was? Is there something else you could have done, or what else could you have done? Why didn't you wait? Are all the gearboxes which failed the test scrapped? Who decides? Do you have the authority? So that's all about the employee and his input and his responsibilities. The next bit is more generally about health and safety. Do you know where the risk assessments for the job are? When did you last read them? Where are they kept? What information is there about lifting the component? Is lifting it by hand common practice? When did you last undertake manual handling training, and how did you know your slinging training had expired? So that's all about, you know, did he understand what the rules were around doing this task? What was his training like? And is this something other people do? Did they lift it by hand, or is it just you went off on a wild thing on your own this time, or is this a practice that has developed amongst the team? And then the last bit is more broadly about health and safety regime in the workplace and the sort of manager's responsibility, I suppose. So when did you last do health and safety training? What PPE do you need for your role? Do you use it? And what conversations have you had with your line manager about health and safety? So those sort of questions. So you can see, depending upon the answers you get here, there might not just be individual responsibility, or there might not even be individual responsibility. It might be the manager's failure, or it might be that bad practice has grown up amongst a group, and either the manager hasn't addressed it or hasn't realised that's what's going on. So there's a number of different potential issues involved in that scenario. The questions for the line manager again follow those kind of three themes in terms of, first of all, his involvement in the actual incident, what he saw, what happened, was anyone else there? What's his view of the allegation the part was going to be scrapped anyway? Is that the employee's decision or somebody else's? Do we know if the part did fail quality check? Why did it fail, and what would that normally mean? So I suppose that's getting at, you know, if it did fail quality check, does that mean it was going to be scrapped, or could it have been saved? And was it the dropping it on the floor that was the final nail in the coffin for the component? The next one's again about the risk assessments. How do you make sure people are aware of them? Where do you keep them? What information is there about how to lift the component? Is lifting it by hand common practice in the team? And when did your team last do the manual handling training? And then again, the last bit is more about the health and safety regime and what the manager's done about health and safety in the team. And the last question I think in particular is, where have you intervened in the past on the alleged health and safety issues? Because the manager's telling me he's asked HR, that reported the employee to HR for help. I would kind of expect HR to have told the manager, well, you have to go and speak to the employee if you see him breaching health and safety rules. So another aspect is more about how did he react, what did he do, did he record it as a near miss, and what was the conversation he had with X, so how did he handle the incident. Other witnesses, again you're covering the three areas. What did you see, what happened, was anyone else there? And then in relation to the lifting practices, is this normal? Do you know what should have been done to avoid it? What would you have done? And if they say something different, why would you have done that? And then general questions about health and safety in the department, about risk assessments, training, how do you know when refresher training is due, etc., etc. So I say we'll send you out the slides and you can study them in more detail yourselves. Moving on to the investigation report. You need to gather everything together at the end in a report. You need to identify fact findings. What did you find as a matter of fact? Does it appear a company rule or policy might have been breached? And is there a case to answer? And what should you do about it? I don't mean penalty by that. I just mean, are you going to move on to disciplinary hearing, or is it going to be occupational health or health and safety? Do we need to refresh a policy? So what actions might happen as a result of the investigation? So you'll be expected to put recommendations in your report about any issues that have been identified requiring action by others. For example, the HR need to refresh a policy, the health and safety need to retrain people. Has a medical issue been identified that OH need to become involved in? Is that a case where we just need to say a bad practice is drawn up? We need to tell everybody, here's the process going forward. If you do it again in future, there'll be potential disciplinary consequences because everyone's been involved. But you can't reinvestigate someone because you don't get the result that you're looking for. You have to deal with the facts that come out of your actual investigation. So in completion, you need to make sure that you've got all the statements from all the relevant witnesses before you decide to progress matters on to whatever stage you decide to go to, if it's discipline or something else. If further information comes out later, investigation can be carried out at disciplinary and appeal stages, and indeed should be if more information comes to light. But it's better to gather it all together at the investigation stage if you can. Be very clear if you do send on to disciplinary hearing what documents you're sending on to the manager and the employee, if that is the next step, and keep a record of what you've sent, because when it ends up at tribunal, people deny having received things and it's hard to prove unless you've actually kept a record. So that's just a plea from me and the legal team, keep a record of what you've sent on. There can be delays because it's not uncommon for employees then to go off with stress, anxiety, depression, at around the time an investigation has been concluded, when you're just about to tell them it's going on to a disciplinary matter, which can be frustrating, but you just need to deal with it, refer it to occupational health in accordance with your normal practice, which hopefully is quite soon if it's a mental health issue, and seek specific advice about how to deal with, is the employee fit to deal with the disciplinary issue? Can they attend an investigation or disciplinary hearing? As well as the kind of normal questions about when will they be fit to come back to work, and is there anything we can do to help them to come back to work? Be patient. It is frustrating. You want this thing dealt with, but you need to be patient. And just the message to get across is that it's not going away just because they've been off sick. It's still there and it will be dealt with when they're fit. If OH can't be clear about when they'll be coming back, or if the time passes and they don't come back as expected, then follow things up with occupational health again and consider taking advice perhaps about alternative methods of dealing with matters, e.g. if they're not fit to come to a meeting, could we deal with it by correspondence, for example? Not ideal, but better than nothing if things reach a bit of a stalemate. So the main point I would make to you is investigation delay is an important part of the process, and anything which is missed or goes wrong at that stage quite often does have a detrimental effect on the later stages. And even if it seems to be a cut and dried case, please don't cut corners. Do a proper investigation. You might have a scenario where an employee decides, well, I'll take that up for somebody else not wearing their PPE because they've already had a couple of warnings. I'll just take that up this time. So you just need to be careful that you do carry out a proper investigation. Deal with all your investigations in the same way, consistently, and don't delay unreasonably. Somebody is waiting uncomfortably for the outcome of your investigation. Keep detailed records of any formal interviews. Preferably, as I said earlier, have them signed and dated by the statement giver. It just gives you a bit more comfort that that is their statement and you can rely on it. And if you're having any informal conversations, for example, you might follow up with somebody if the employee raises something, a sort of trivial point, you might follow up with somebody else, another witness. So keep a record of that as well, even if it's a less formal conversation. And it's always worthwhile, if you have time, to have a look at previous cases once you've concluded matters for learning, to analyse, did we deal with this properly? Is there anything we need to improve? Did it take too long? Did we miss something out and have to go back? Could we do it better? So it's always worth doing that. That concludes the formal bit of the presentation. So I'm now going to invite any questions in the chat. So Jimmy's asked where we can get training for line managers. It is something, Jimmy, that we can offer if you want to speak to Dermot or myself offline. Anyone else got any questions? No, everyone's stunned into silence this morning, I think. I'll just leave another minute, and thanks very much to everyone for attending. I was really pleased to see such a great turnout for main holiday season. It's, I would suggest all of you need to take a holiday now. Thanks all for attending, and have a good rest of the day.
Oh, hang on.
Oh, John Bennett, you've got something. If you want to put it in the chat, I'll hang on. If you want to put it in. About suspension. Well, I'll hang on, John. I'll just keep it on. If you want to type in your question, if you're not able to speak, I'll hang on. And anyone else who wants to stay or leave, do as you wish. Thank you very much.
Thanks, Lindsay.
Thanks, Lindsay.
Cheers. So what if you believe the employee is risking sabotaging? I guess that's one of the scenarios where, John, you could potentially suspend pending investigation if you had a real belief that they were going to do something inappropriate, like, I don't know, wreck some sort of software package or destroy records. That's a situation in which you could potentially suspend, but you'd need to have some sort of concrete information rather than just a suspicion. At some point, commercial reality will bite in and you'll take a chance and think, I really suspect this, I've got no evidence, but I'm still going to, take steps to protect the business, in which case you just take your chances. I think everyone will have a point at which they just decide to act. So hopefully that answers your question, John. If you do want to follow up with Dermot myself, just stick an email. Yes, we'll share the slides. They'll be sent out after the presentation. Thanks very much. Okay, everybody, thank you.